Okay, great. Good afternoon, and welcome to the Office of Tax Appeals. My name is Kim Wilson, and this is the hearing for the appeal of Hackney. A stenographer, Ms. Alonso, is present and reporting this hearing verbatim. To ensure we have an accurate record, we ask that each person speaks one at a time and avoid speaking over one another. Also speak clearly and loudly. When needed, Ms. Alonso or myself or any panel member will interject to ensure proper transcription. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The Office of Tax Appeals is not a court, but an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we establish a proper record on which a decision is based and to conduct an orderly hearing. Each party will have the opportunity to be heard, so please wait for your turn to present your side. Any questions before we go on the record? No questions? All right, Ms. Alonso, are you ready? Panel? Yes? Okay, great. We are going on the record. This is the appeal of Hackney, OTA case number 2405-16261. The date is August 13th, 2025, and the time is approximately 1:30. The hearing is being held in Cerritos, California. I am hearing officer Kim Wilson, and with me are Judge Kletter and Judge Stanley. I will be the lead panel member for the purpose of conducting this hearing, but we are equal participants in deliberating and determining the outcome of the appeal. And then for the record, could you please identify yourself?
Philip Scalisi, executor.
Thank you.
Kenneth Mousseau, enrolled agent representing the estate.
Thank you. And Franchise Tax Board?
This is John Lee from Franchise Tax Board.
And Jackie Zumaida for Franchise Tax Board.
Thank you. As stated in the minutes and orders, the issue to be decided in this appeal is whether appellant has established a legal basis to suspend the statute of limitations on the claim for refund filed for the 2018 tax year. FTB submitted exhibits A through I. Appellants did not object to the admissibility of these exhibits. Following the pre-hearing conference, FTB submitted an additional exhibit, J. Mr. Scalisi or Mr. Mousseau, do you have any objections to Exhibit J, which is the IRS transcript? Okay.
No.
Thank you. Therefore, Exhibits A through J are admitted into evidence. I did not note any additional exhibits from the appellant. Is that correct?
That is correct.
Thank you. All right. You did indicate that you would like to provide witness testimony, both of you. So I will swear you under oath. Would you both please raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Yes.
Thank you. So you asked for 15 minutes for your presentation, and you may begin when you're ready.
Probably not necessary for the whole 15 minutes, but I just wanted to review. Thank you. I appreciate you y'all hearing the case today and for giving us an opportunity to speak. We are here on behalf of Aunt Lucy, Lucia Hackney, passed away July 23rd, 2023. We are Mr. Scalisi is the executor, current executor of the trust and will, and we are here basically to explain some scenarios and express a little bit of frustration over the statute of limitations and the overpayments that weren't refunded. Just to back up a little bit, the reason there was a balance due was 2018 for Aunt Lucy. She sold her house as her health was declining and believed she paid all the taxes or was not necessarily needing to pay the taxes when she sold the house. She had not been filing her tax returns as her health was diminishing, but her intent was to not to skirt to paying taxes that she thought they were already paid on her behalf. So I'm basically going off of our exhibit here, our appeals letter. Just wanted to make sure it was recorded properly in the court. In March 4th, 2021, she was determined to be incapable of handling her own financial matters, and on April 9th, Patty Pastilli, who was Aunt Lucy's niece, basically resigned as the executor, making Mr. Phil Scalisi the executor. Upon that day, he was handed a pile of documents and was made aware of several of Aunt Lucy's back tax issues, including the 2018 notice. Exhibit C in there was the final notice before levy or lien, dated April 7th, 2021, which was obviously right before Mr. Scalisi took over. And I guess as part of my questioning here to Mr. Scalisi has been, what are you a good taxpayer? And what is your opinion? What do you normally do when you receive a letter from the IRS or the Franchise Tax Board, and that is to just snap it, pay it, make sure it's taken care of? And in this case, one of his first acts was to make sure that this balance due was paid out of the estate, and paid $13,914. At that point, Mr. Scalisi understanding was that the $13,914.29 was satisfying the 2018 liability, not knowing at that point, didn't realize that the tax return was not filed. The payment, like I said, was made as a snap judgment in fear of more repercussions from the government, and he thought the state obligation was satisfied. When he came to me, in between coming to me and that payment, as stated in my appeals letter, the payment was made, a second payment was made March 28th, 2022. It was paid online for $6,256. There's where things get sketchy. We understand that. We don't know who made the payment. We don't know why that number came up as a payment. When I finally prepared the tax return, it was very similar to that amount. We believe that, and again, this is speculation, but we believe that Aunt Lucy was still working with her niece Patty, the former executor, and dealing with a separate tax preparer. And as in Exhibit J, 2 payments were made that day, one to the Franchise Tax Board for $6,256 and one to the IRS for $19,476. Something happened that day where payments were made. We don't know what happened or how those amounts were calculated. Kind of fishy there. We believe, like I said, Miss Hackney was participating in her own financial decisions. We have some other cases where that may have happened, where she had been paying her own bills or doing things she probably wasn't capable of doing. It's our belief that a tax return was prepared and a payment was made with the understanding that 2018 would be closed. In other cases that I have, every time a tax payment is made and a liability is satisfied, and then I have several cases where a payment is made to the wrong account year or the wrong tax year, the wrong account, and they have to be moved around. But in essence, if there is an overpayment of a tax that is generally refunded or moved to a different year, it is not, there's sometimes the Franchise Tax Board is nice enough to send a letter that says, hey, you have a balance due, where we need to call them and move the payments around. So we were not under the impression that there was any, didn't understand why this $6,000 payment didn't get repaid. $6,256 did not get repaid, thinking that everything was, the liability was settled. We don't know where the payment went to or came from. We believe that payment should, understanding the statute of limitations, the $13,914 that was originally paid shouldn't have been paid in the first place, because that was not the correct tax liability. That was just based off a substitute filed return, which I know there are legal basis to file a substitute filed return, but I don't ever believe ethically that's a good thing for the Franchise Tax Board to do. So, like I said, we're here to express more frustration than anything. So we're basically thinking that the $6,256 would be, that was an overpayment, beyond the statute of limitations of the $13,000. There was $20,000 paid on this account, and only should have been $6,200. We're not even really asking for the $13,000 back. We think that the $6,256 should be repaid because everything should have been satisfied. And I know that in your response in the appeals, anything voluntarily paid before the return is filed is not considered overpayments according to this statute. We believe that the statute of limitations should have been moved up to the time of the tax filing in 2024 when it was actually received. But do you have anything you want to add? No? Okay. That's what I have.
Thank you. Franchise Tax Board, did you have any questions for the witness?
No questions from Franchise Tax Board. Thank you.
Thank you. Judge Clutter?
No questions. Thank you.
Judge Stanley?
Not at this time, thank you.
All right. We'll go ahead and move to Franchise Tax Board's presentation. Mr. Lee, you have 10 minutes for your presentation. Please begin.
Thank you. Good afternoon. I, John Lee, along with Jackie Zumaeda, represent the respondent in Franchise Tax Board. The issue is whether an appellant has established that a timely claim for refund for the 2018 tax year was filed before the statute of limitations expired. Unfortunately, the evidence will show that appellant did not as to the barred overpayment. Under the applicable section of the Revenue and Taxation Code, the general statute of limitations provides that the last date of file claim for refund is a later of 4 years from the date the return was filed, if it was filed within the extended due date, 4 years from the due date of the return without regard to extensions, or 1 year from the date of overpayment. For the 2018 tax year, as appellant failed to file a timely return, the 4-year statute of limitations expired on April 15, 2023, 1 year before appellant late filed her original 2018 return on April 15, 2024. Under the 1-year statute of limitations, appellant's payments on her 2018 tax year count were made over 1 year prior to her claim for refund. Therefore, the 1-year statute of limitations is also unavailable to allow a refund of appellant's overpayment for the 2018 tax year. On appeal, appellant contends that she was financially disabled during the applicable statute of limitations period. According to law, an individual taxpayer shall not be considered to be financially disabled for any period during which an individual spouse or any other person is legally authorized to act on the individual's behalf in financial matters. In the appellant's Form 1564, it is stated that she did have persons legally authorized to act on her behalf in financial matters during the entirety of the statute of limitations period. As such, appellant has not established financial disability to toll the statute of limitations and allow a refund of her overpayment. Appellant also contends that an earlier return may have been filed in 2022. However, respondent's records do not show that appellant previously filed a 2018 return. Furthermore, appellant's 2018 federal account transcript does not show that a return was received by the IRS in 2022. The law requires appellant to provide compelling proof that a return was filed before the statutory deadline. Appellant has not provided a certified mailing receipt to show that a timely claim was filed. Appellant further contends that respondent should refund the last voluntary payment on her 2018 tax year account, as the payment was remitted after the account was fully paid. When a taxpayer remits a payment, the law prevents respondent from issuing refunds unless a claim for refund is filed before the expiration of the statute of limitations. The language of the statute of limitations is explicit and must be strictly construed. In the presidential opinion of the appeal of Gillespie, Ote held that there is no equitable basis for suspending the statute of limitations. Moreover, the United States Supreme Court in United States v. Dahm explained that a taxpayer's failure to file a claim for refund or credit within the statute of limitations bars a refund or credit even when it is later shown that the tax was not owed in the first instance. Appellant has not provided any additional evidence that would allow respondent by law to grant her claim for refund. Therefore, respondent respectfully requests that the Office of Tax Appeals sustain respondent's claim for refund denial for the 2018 tax year. Thank you, and I'm happy to answer any questions.
Thank you. Judge Stanley, do you have a question?
Yes, I do for appellant. You didn't address in your presentation anything with respect to financial disability, and I see that you have a doctor's letter and an affidavit regarding the decedent's financial disability. But can you address in any way who was authorized to act on Aunt Lucy's behalf during the relevant time periods?
That would be my cousin, Patricia Pastilli. She was in charge of all her finances until 2021, I think it was. And then there was sort of like a transition period where I took over and saw the mess that I had to deal with. And I mean, that's all I have on that.
Okay, could I ask you to spell that name that you just stated, Patricia?
Patricia Pistilli.
Can I continue with that? Cousin Patty has since come to me and as a client, and not the most organized of persons. This is why she kind of took over, or handed it off to Mr. Scalisi here. No, we did not. At no point are we saying that Aunt Lucy was financially disabled. It was mentally. I mean, she was, I don't know if that's the same term here in the courts, but she basically was diagnosed with dementia. And as most things with dementia, most patients with dementia, there's things going on that executor can't control, or going, like I said, going behind the back and paying a bill or something, and then it gets paid twice, or it wasn't an intent, and she certainly wasn't financially disabled. Obviously, they were making these payments on her behalf, so that's never been the claim of financially disabled. It's more of a mental health disability. So,
And if I could, just to clarify for you, financial disability is a term used in the law that can be either mental and or physical impairment of a certain duration that makes her unable to be able to manage her own finances. So that's why I use that particular term. Did you Mr. Scalise, did you ever address the issue of the taxes with the prior trustee then?
No, I didn't, because she was pretty much clueless on everything. She would just put everything on the back burner and forget about it until we started getting notices of demand of payment. So basically, I took everything from her at that point and just started just paying. Like when I got the first notice from the franchise tax board saying they were going to levy all their retirement accounts, I just immediately sent out that $13,000. And just from then on, I just kept on, Ken and I worked together to try to straighten out 5 years of taxes, I think it is, that they basically just left to the wayside.
Okay, thank you.
Sorry, and you can see, what is this, Exhibit I? Like when Mr. Scalise retained me, we got right on it and started filing the returns. And the back, it was 18, 19, 20, 21, 22, 23 were all filed basically at the same time. So we were trying to clean up the mess. So I know there's, we didn't bring very much in the way of statutes. We're basically talking about intent and what our intents were and what we could do and what we could handle. So that's the last of probably what I'd say.
Judge Clutter, do you have a question?
This is Judge Clutter. No questions. Thank you.
You have like 5 minutes if you'd like for a rebuttal or closing statements.
I think this is more about intent than anything. I mean, we were not. I know there are some cases. I haven't found any statute, but I know there's some cases of intent is sometimes as what is just is what we're talking about here, and I don't find that taking $13,000 from an estate. Even after, I just don't find that just at all. Even though the statute of limitations we're well aware of statute of limitations issues. We believe, though, that the statute of limitations really should be from the time of the filing, especially when there's a substitute file return. The substitute file return is something I will always have an issue with the state of California. I understand that there's a lot of negligent taxpayers out there, including probably the former executor in this case. So we're basing most of this on intent. As a good taxpayer, getting a letter from recognizing that you get a letter from a tax entity, you're going to pay that right away, and that's what we believe both Phil did, and even in her diminished capacity, Aunt Lucy did. That's where we think those payments came from. To the IRS and to the Franchise Tax Board back in March of 2022. So,
Thank you. We'll go ahead and submit the case. Today is August 13th. The case is submitted. The record is now closed. Thank you, everyone, for participating today. The panel will meet and deliberate and decide your case. We will issue a written opinion within 100 days from today. Today's hearing in the appeal of Hackney is now concluded, and this concludes the hearing calendar for today. Thank you.